It can be hard to track the fast and furious pace of bills during Florida's legislative session. Here to slow down one proposal that could cost local communities millions is Jim Kowalski, President and Chief Executive Officer at Jacksonville Area Legal Aid. Good morning, Jim.
Good morning. Thanks for having me.
So, Jim, there have been a couple of bills that Legal Aid is following in the legislature. And let's start with one that's being heard at a meeting this morning at the Senate Judiciary Committee. We can get into the details of Senate Bill 498 and how it would work. But let's sort of start at the end instead of the beginning. What would be the financial impact on Florida's legal aid community if this bill passed?
So the funding for statewide legal aid has increased dramatically because of a change the Supreme Court made to a rule that regulates lawyers. And what's happening now in Tallahassee, as you mentioned, the first hearing is today in the Senate, would then cut that increase by about 2/3 statewide. So we had a significant increase, and now we're facing an enormous decrease.
For people who aren't familiar, what is legal aid, the recipient of this funding?
So lawyers have to have trust accounts, right? We have trust accounts and operating accounts, and the trust accounts are client money. So think of a lawyer that does real estate closings. When you close on a house, that money goes into that lawyer's trust account and then gets dispersed to the seller, to the closing agent, to the broker, to somebody who does an appraisal. For the few seconds or minutes or days or months that money is sitting in a trust account, it's earning little pieces of interest. And Florida was the first state in the country to say those little pieces of interest, because we can't figure out mathematically which client or how much of a client they should go to, we're going to send them to a central agency, and that will support legal services for the poor. It's called IOTA, or interest on trust accounts. And that's the funding we're talking about. It's controlled by the Supreme Court. The bar looks at it, and there's an entity called the Florida Bar Foundation, now known as Funding Florida Legal Aid, that actually receives that money from those banks that work with lawyers and then sends it out to legal aid all over the state.
And legal aid uses it to do what? Like, what is the mission of legal aid around the state?
So we represent low-income and at-risk individuals in civil court. The easy example would be a senior in a reverse mortgage foreclosure. We know that banks make mistakes. There are many seniors who are facing reverse mortgage foreclosures that are solvable. We can keep that senior in the home, but private lawyers don't represent seniors in reverse mortgage foreclosure cases because there's no money in it. That's a typical role for civil legal aid. Another typical role would be eviction. There are evictions that are wrongful. We work with the city, for example. The city of Jacksonville has an eviction diversion program that we developed with the court system, with Jewish families, and with United Way. That helps keep people housed, where we know that not being housed, being homeless, is much more expensive for a society than keeping somebody housed. So those are two easy traditional roles for civil legal aid that we would use IOTA money to support.
So we know that under the law, if somebody's charged with a crime and they can't afford an attorney on the criminal side, they'll be provided one by the court. There is no such provision when it comes to civil matters. And that is sort of what legal aid serves, is helping those people. But it doesn't have a dedicated funding source in the state budget, unlike most other states.
Yeah, unlike 48 other states. But that's a really great analogy. It's similar to the right to a lawyer in criminal court. You have no right to counsel in civil court. That is the traditional role civil legal aid plays. And in 48 other states, like Texas, those states dedicate sometimes tens and hundreds of millions of dollars of state money. Florida and Iowa are the two states in the nation that dedicate zero general state support for civil legal aid, which is why we've always been so reliant on IOTA. It's a non-taxpayer source. It's supervised and controlled by the Supreme Court that has the job of regulating lawyers under the state constitution, and it flows to civil legal aid law firms all across the state like JALA.
So this proposal, as you say, would cut funding statewide by approximately 2/3. It would cut that IOTA trust fund money that goes to legal aid around the state. Why is that being proposed? Who is proposing this measure?
So what we know now is while the 170 banks are participating and working with local law firms, we have 2 IOTA accounts ourselves with Regions. While 170 banks are participating, there are a few banks, mainly on the West Coast, that don't appreciate that this money isn't going back to them, right? If it doesn't go to the Florida Bar Foundation, it's simply profit for the banks. And so when the Supreme Court tweaked the interest rate rule that we have to follow as lawyers, we have to work with banks that will follow the Supreme Court rule that applies to us. A small number of banks, a very small minority of banks, are now going to the legislature saying, hey, we need you to put your thumb back on the scale for us. We'd rather keep that money. We think it's too much to give to Florida Civil Legal Aid.
The rule change a couple of years ago basically said, and correct me if I'm wrong in this, but basically said that lawyers who are creating these trust funds have to make sure that they're working with banks that offer basically the best possible rate of return on those trust funds, so that the IOTA account must be able to get at least as much interest on their trust fund account as, say, any other kind of similar trust fund account that the bank offers. Is that correct?
That's exactly what the rule said, and it has said for many, many years. But what happened once interest rates started going back up, right? Once the Fed increased interest rates, obviously during the recession they went to zero. But once the Fed increased those interest rates, the disparity between the banks that were paying the rule rate voluntarily and those that weren't became much more clear. And the Supreme Court then said, okay, we've told you, lawyers, you need to work with banks that pay the highest comparable rate. There's a group here that aren't. So we're going to tell you what the highest comparable rate is, and we're going to say you have to work with banks that will comply with what we say to you as lawyers. And that's when the income jumped, and that's when we all realized, oh, wait, these banks were simply pocketing this money as opposed to remitting it to the Florida Bar Foundation for Civil Legal Aid.
And I think, to be fair, these banks that have brought this amendment proposal would say, look, you're asking for this enormous, almost overnight increase in what we had been providing as interest. It's unreasonable. We should at least have time to phase it in, as opposed to just all of a sudden having to shell out this enormous amount of money.
Agreed, and I would agree with that. Typically, we don't want too much of a disruption to any single sector of business. But the fact is there are 170 banks that are now compliant, that were compliant early and have said, yeah, we can take this change to our business model and we still want to play in this space because we still think it's profitable for us. We still think it's profitable to work with lawyers and then send this interest to the Florida Bar Foundation. There's a small minority who've said, no, we'd really like to keep that money as opposed to sending it. We'd like to keep it as profits for ourselves.
So that money that legal aid receives statewide, some of that increase that resulted from the increase in insurance rates went to a reserve fund. And I think that that's also part of the question as to whether legal aid should be putting money into reserves when it has this money. And perhaps the banking folks that oppose that are saying, look, you know, some of that money is obviously unnecessary. It's going into this reserve account.
Right. So 2 things. Number one, we being Civil Legal Aid, didn't ask the Supreme Court to set up reserves. We didn't say this is a good idea. We said we can overwhelmingly spend this and deploy it on the street. But the Supreme Court gets to regulate us, and objectively, businesses having a reserve in a time of high return is objectively a good idea. So even though we said we could spend it, we're certainly not objecting to the Supreme Court disagreeing with us and deciding that reserves are a better idea. And we know from very recent past that the Florida Bar Foundation, having had reserves at the beginning of the recession, helped them support civil legal aid for years after interest rates went to zero. So as any business, you want to kind of zero out the waves, and reserves are a way to do that. But our main pushback to that point is, hey, it's not a windfall. We could have deployed it, but we also want to make sure that we have the funds to deploy in the future.
So talk about how you could use that money. I mean, Jacksonville Area Legal Aid serves, I think, a 17 county area in North and North Central Florida. You have thousands of clients, but what is your estimate of how, if you were able to use even a portion of that reserve, how that would be spent?
Well, so just look at what we've done with the increase that we just received and that we received last year. We've added a lawyer in St. Johns County. For the very first time, with some help from the Nassau County Commission and the Center for Aging in Nassau County, we now have a full-time Nassau County attorney. We're adding lawyers in our pro bono unit so we can better serve some of our rural counties. And then some of the things that have been decreased, right? We've all seen entities that serve domestic violence victims get federal funding from a trust fund called the VOCA Fund. This is domestic violence shelters, domestic violence legal aid lawyers, those types of entities. That has been cut. So this is a chance to keep that work for our most vulnerable citizens going using IOTA instead of VOCA, for example. All of that we've already done, and we will continue to do in the future as long as this funding stream stays secure and the current effort is pushed back.
So we know that if there is not a legal aid attorney available, it doesn't mean the case goes away. So what do we know about cases that proceed where the person that's involved in the civil litigation is representing themselves?
So we know generally they're far slower. We know the success rate in cases such as eviction and debt collection. Wrongful debt collection is another area we focus on. We know from statistics that the failure rate of those individuals not being able to explain their positions to a court is overwhelmingly high. And we know when somebody is represented, those losses are substantially cut, particularly in those two areas where the self-represented numbers are still so high.
Because they can really create a backlog.
It slows things down for the courts. It means that businesses that want to have a dispute in court can't get their day in court because the judges are working with an overflow of pro se unrepresented litigants. It messes up the whole system.
If you're just joining us, we are talking to Jacksonville Area Legal Aid CEO Jim Kowalski about legislation the group is watching in Tallahassee. You can join the conversation by giving us a call at 904-549-2937. You can also email firstcoastconnect@wjct.org. I want to ask you about a different measure that you were watching that you were successful last week in defeating. Tell us a little bit about this. Was a very small change to a Consumer Collection Practices Act, basically language that protects consumers during debt collection.
So Florida has a strong act that applies to efforts to collect a debt. It is called the Florida Consumer Collection Practices Act. People may have heard of the federal counterpart, which is called the FDCPA, the Fair Debt Collection Practices Act on the federal level. The Florida Act was broader, and it applied to landlords, it applies to HOAs and COAs, it applies to car dealers. And what it does is it prevents people from using really abusive practices in the collection of a debt. We use it all the time, our consumer team, and private practice consumer protection lawyers use it all the time. And so, as you mentioned, last week, a number of us went to Tallahassee because we had learned of a very late 2-word tweak that would have ended the statute. And it was very interesting to participate in that process, to engage in that direct democracy, to speak to our senators, and we were successful. We defeated the amendment that would have changed those 2 words in its very first hearing before the Florida Senate. So it was very interesting and exciting to watch and be a part of.
And so this change basically would have modified the language. Instead of saying that any person was prohibited from these certain practices, to saying any debt collectors were prohibited from these practices. So Explain to us, first of all, what the practices are specifically that the language of the law prohibits and why changing it from any person to any debt collector would make a difference.
So let me give you an example. This is what I said during my testimony. I just flipped the statute if it had passed, the amendment had passed, and those two words were taken out. So in collecting a consumer debts, a door-to-door scammer would have been able to pretend to be a police officer or use or threaten force or violence. A landlord would have been able to threaten to call a tenant's employer in order to collect without ever going to court or even confirming the amount was correct, or harass or abuse the tenant, or use profane, obscene, vulgar, or willfully abusive language in communicating with the tenant and any member of his or her family. An HOA or a COA would have been able to threaten to enforce a debt they know is not legitimate or use fake government communications and pretend to be a government employee. All of those are quotes from the statute. We just flipped it to say if you take out these two words, all of those things are now possible in Florida, whereas yesterday they would have been prohibited.
So these are things that a contractor could come to your door, pretend to be law enforcement to try to collect a debt, could talk to your neighbors about your debt, could call your employer.
Right, and we see those things anyway. That was part of what we were trying to share. We had actual examples of cases we had filed and other consumer protection lawyers had filed using the FCCPA. The bad actors are already violating it. Imagine if it was legal to violate it and we didn't have that statute. But one of the easy examples, like you picked up on, was what happens after a storm in the First Coast. We have door-to-door contractors that come up and they say, hey, we noticed there's a shingle missing. We'll get your entire roof repaired. We'll bill your insurance company, or there's a government program, or we'll put solar up and JEA will now pay you, or you'll get a cut on your taxes. Zero of which are true. But if the homeowner then doesn't pay, they use these abusive tactics. They apply liens to the homes, and in many cases, our cases involve attempts to foreclose those liens and actually take the homes. So another traditional role for civil legal aid. In this case, private consumer protection lawyers also do that as well.
And we know that seniors can be particularly vulnerable to these tactics. What is the situation when it comes to seniors' exposure to fraud and attempted scams?
It is enormous, and it is increasing. So part of what we try to do with our education, part of what we do with the other agencies locally that serve seniors and work with seniors is try to get the word out. When something like this is happening, to your mom or dad, you notice contract work at their house when you come over to visit, ask those questions. There's something that's happening. Typically, they're using some sort of a digital signature. Somebody's signing on an iPhone or an iPad. What they're actually agreeing to is an entire contract that's sitting behind that screen that is supposed to be delivered to them immediately by email. And we know in some of these cases, the email addresses are just made up, or the senior may not use email to communicate and never get that copy of the contract and even know what they've agreed to. So we're very watchful for these types of scams affecting our seniors, particularly in Florida.
So you said that this amendment would have affected kind of state protections. There are some federal protections, but these specific ones that you're talking about, the sort of landlord fraud, the contractor, that stuff needs this state language to protect these people. So who's on the other side? Who's proposing changing this language?
So we don't know, right? The initial bill had a little tweak to how you can communicate somebody that you already have a business relationship with. And we didn't object to the original draft of the statute, making this little correction. We thought it was an okay idea. It didn't affect our cases. But then very late in the process, the hearing was last Wednesday in front of the Senate Commerce and Tourism Committee. Very late in the process, I think Thursday, Wednesday, the week before, less than a week notice, we learned of this attempt to change those two words that you've talked about. And we kind of panicked and responded.
So you learned about it, but it's not clear, I mean, from the lawmaker that introduced it, where this language came from or who was proposing it?
No. and we still don't know. We know that the debt collection industry tries this with this particular statute. The last time, I think, was about 9 years ago. So it is something we try to have our radar up for, our spidey sense up for, but this was very late in the game. But again, the process worked, right? We reached out to the senators. We spent the morning meeting with staff. The hearing was in the afternoon. A couple of us testified, and it was unanimously defeated. So it was as much these days as it may be hard to engage in direct democracy and reach out to your elected officials. And I'm as guilty of sometimes being jaded about that as anybody. It worked. We were successful. It was great to get the win. And we saved this huge consumer protection statute for the state.
Just a couple of messages. One from Michael emailing, pound for pound, Jacksonville Area Legal Aid attorneys are the best in Northeast Florida. The plan to reduce their income is another example of the malign MAGA influence. Also a message on Instagram saying, always a pleasure to have Jacksonville Area Legal Aid on the air. I want to ask you about that participatory effort that you all made and your success in defeating that particular amendment. This is a very shortened runway that we have this legislative season. Can you kind of explain why that is and why that presents some additional challenges for lawmakers and citizens?
Sure. So this is something we actually heard about during the effort to defeat the amendment to 55972, the Florida Consumer Collection Practices Act. When there's a special session, the actual regular session is truncated. It's shrunk by however long the special session is. So what we found out was that many of the aides, for example, that we were meeting with and calling and texting and sending letters to, hadn't had time to figure out what this bill was about or the substantial change it would affect on Florida. And so it made it more important to be there and try to show the change. And the same for this next bill, Senate Bill 498 on changing IOTA. The legislators in our state, running the third largest state in the country, have a very short amount of time to work through their actual session, and even less time now because of the special sessions.
Because even though the timing of this regular session didn't change, the weeks before a regular session begins, if there isn't a special session, is often spent with these kinds of meetings where people are familiarizing themselves with the content of the legislation that's being proposed.
And it's quieter, right? You can go there and have some longer discussions. You can sit in a conference room over coffee and really kind of work out the causes and effects of a particular piece of legislation. Here, though, we're going in on a Wednesday morning and the hearing's Wednesday afternoon, and we've spent the last 48 hours, and that's it, right? So that's what made it all the more startling that the amendment was unanimously defeated during the hearing. We won't have to go back throughout the rest of the legislative session, even though we're obviously watching this bill as it tracks through the House and Senate. And so far, no attempt has been made to amend it to remove those two words.
So that's a win, but in terms of other legislation, are you anticipating anything else might crop up?
I think all the bills that have been filed or can be filed have been filed. So right now, the two big ones that are affecting civil legal aid and our clients most particularly are the shift to the IOTA rule, as you've talked about, and this other amendment that we defeated but are still watching.
Well, it is amazing how the minutia of legislation can have such consequential impacts. But Jim Kowalski, thanks so much for flagging that for us and for the work that you do with Jacksonville Area Legal Aid.
Again, thank you so much for having us this morning.